6 of the complaint herein, defendant affirms in part based on his knowledge of the incident. Plaintiffs are attorneys of the defunct Grandview Palace and represent the board in all matters. Plaintiff Brian ROURKE is an elected local judge for the town of Liberty, New York, and therefore held to a higher standard. Plaintiffs have not shown an attorney retainer/contract stating that they truly represent Grandview Palace as attorneys, for they hold sway, act, and function like a dictatorial board of managers and represents the HOA in all matters. The board of managers are mostly octogenarians and nonagenarian, frail, sickly, and lacks the knowledge, strength, and experience to understand or protect the Grandview Palace Homeowners Association's best interests. Plaintiffs are taking advantage of the age and ill health of the board and instituted complete attorney/judge control and authority over the inept Grandview Palace Board of Managers. Plaintiffs as Grandview Palace HOA attorneys have wrongfully advised, directed, enforced, and have violated many articles of the HOA bylaws, First Amendment right, New York state laws, and New York Lawyers' Code of Professional Responsibility, such as denying and suppressing voting right against Article 3 Section 8 of the bylaws, illegally charging maintenance when everything burned down and there is nothing to maintain, allowing the buildings to continue without proper certificate of occupancy and fire protection, thereby burning them down, demanding an illegal maintenance fee of $90 per month when the property does not have a proper certificate of occupancy, putting liens on unit owners in good standing without proper due process of law, demanding fees without a budget and a proper explanation of the spending of funds, against Article 6 Section 1 of the bylaws, voted HOA-owned units to stay in power against the bylaws, Article 2 Section 2, I, withhold and denying access of fire insurance policies to units owners to settle their private insurance claims, prevented and blocked an attempt to legally remove the Board of Manager against Article 4 Section 3, wrongfully withholding financial records and failed to produce such records upon demands, invoice padding by charging $5,000 for $260 small claims court case and failed to show up in court to defend it, wrongfully advised HOA not to bring building up to code and this action led to the fire, controlled and managed every aspect of HOA accounts, receivables, payables, all banking, telephone inquiries, bookkeeping, answering phone calls, etc. To find out arrears, HOA members must go through attorneys. Provided bad advised and purchased units using HOA funds, causing the HOA to suffer a loss of $100,000 against bylaws Article 8 Section 2. Defendant claims that these poor judgments and bad advice made in bad faith by plaintiffs are evidences of legal malpractice, misrepresentation, misconduct, negligence, breach of fiduciary, ethical and contractual duties as alleged in the plaintiff's Exhibit A and reported to the government for actions. Moreover, defendant is a member of Grandview Palace Condominium Association, HOA, and therefore, a client of plaintiffs. Plaintiffs are suing their client. This is against legal ethics and in violations of New York State Unified Court System, Rules of Professional Conduct. Answering the allegations of paragraph 7 of the complaint herein, defendant disagrees. Plaintiff's paragraph 7 states that defendant Peter Perrineau had been an owner of one of the residential condominium units at the Grandview Palace. Defendant Peter Perrineau still owns a unit at Grandview Palace and is entitled to all voting and other rights of ownership, especially his share of the $74 million insurance claim settlement. By this false statement, plaintiffs have successfully stifled and denied defendant and others of their voting rights in direct violations of the First Amendment and the bylaws Article 3 Section 8. Plaintiffs did in fact deny defendant and others from speaking, asking questions, and voting at HOA general meetings on November 18, 2012. Plaintiffs knowingly committed fraud and perjury. For this is another sworn false statement made in the verified complaint, with the intent to deceive the court, in order to obtain a favorable judgment and denying defendant of his voting rights and share of the insurance proceeds. New York Penal Article 210, Perjury and Related Offenses. Answering the allegations of paragraph 8 of the complaint herein, defendant disagrees. Plaintiff's paragraph 8 states that on or about April 14, 2012, a fire consumed most of the entire Grandview Palace condominium complex, destroying most of the residential units and rendering the remaining units uninhabitable. Defendant claims and can prove that the sworn statement by plaintiff's paragraph 8 is also false. This is plaintiff's fifth count of sworn false statements. Grandview Palace complex is not uninhabitable and people are living there with the knowledge and permission of plaintiffs. At least, Dr. Dulick and Ms. Consuelo are living in Unit J, 100. Plaintiffs negotiated the agreement that allowed them to remain on the complex, living on a declared asbestos-contaminated pit, in total disregard for their life, safety, and welfare. Plaintiffs endanger life, health, and safety, violating the laws of decency. Plaintiffs did in fact knowingly let and allowed people to live in the complex after it was declared a contaminated hazardous waste site. Town of Fallsburg Building Inspector Molly Messenger can verify this fact and further explain the mysterious and alleged illegal acts surrounding the bizarre decision to let people live on a contaminated, hazardous waste site. Yet, plaintiffs, to retrieve their belongings, memorial pictures and other sentimental objects and to make peace and closure with the disaster, and to investigate the cause of the fire, deny unit owners and fire investigators on the grounds. Defendant respectfully requests the court to order that plaintiffs open the gates and let people see, deal, and make peace with the disaster, for there could not be any danger from asbestos. People demand closure from this life-changing disaster, and plaintiffs are preventing and denying the right to mourn and grieve. This is the fifth count of sworn false statement by plaintiffs. Plaintiffs knowingly committed fraud and perjury, by making sworn false statements in the verified complaint, with the intent to deceive the courts, in order to obtain a favorable judgment. New York Penal Code Article 210, Perjury and Related Offenses states, swear falsely. A person swears falsely when he intentionally makes a false statement which he does not believe to be true, a. while giving testimony, or b. under oath in a subscribed written instrument. First-degree perjury will result in a sentence including imprisonment for 3 to 7 years, a fine of up to $5,000, or both. Defendant respectfully requests that the court refer these allegations to the district attorney for further investigation and prosecution. Pursuant to Civil Practice Law and Rules 3211, knowingly making sworn false statements are grounds for dismissal of this claim. Defendant hereby respectfully requests a summary judgment that this lawsuit be dismissed for, if one part is incorrect or false, then the entire document is false or defective, especially if based on fraud and perjury. Answering the allegations of paragraph 9 of the complaint herein, defendant agrees. Plaintiff's statement in paragraph 9 states that subsequent to the fire, the defendant commenced a course of conduct questioning virtually every determination made by the Board of Managers of Grandview Palace. Defendant admitted to exercising his First Amendment rights to questioning everything. How can a lawyer and a judge sue someone for questioning everything? By this statement alone, plaintiffs admitted to filing this lawsuit to stop defendant from questioning everything, a right afforded to defendant under the U.S. Constitution, New York civil rights laws, common laws, and common sense laws. Plaintiff's basis for suing in paragraph 9 clearly states the true cause for this frivolous, strategic lawsuit against public participation, SLAPP. Plaintiffs are suing defendant for questioning everything. The statement alone render plaintiff's lawsuit as a strong-arm tactics to silence, intimidate and coerce defendant from speaking out and to withdraw the active, attorney preliminary inquiry complaint form filed with the Supreme Court, Appellate Division, 3rd Judicial Department. The Appellate Division is currently investigating the complaints made against plaintiffs. On or about May 1, 2012, defendant was one of the parties that started and administered a Facebook page, Grandview Palace, New York, a social media and open forum on the internet. The Facebook page is like the press, a free, public, internet page, where anyone can publish, express and share their ideas, opinions, and information, write and post over the internet under any identity. Fearing reprisals from the HOA Board of Managers and plaintiffs, for posting, writing, reading, and exercising their right to free speech, such as this lawsuit, it was decided, from the beginning, to distribute the password among many. Defendant is not the only one with the password and not the only one posting on the Facebook page. Contrary to plaintiff's beliefs, defendant does not control who or what is posted on the internet. The Facebook page was started as a means to disseminate information, news and provide support for the 2,000 displaced, homeless, lost, emotionally, physically, and financially battered residents, dealing with the pain and suffering of the unforgettable disaster of being burned out and made homeless. The Facebook page reported on and published relief aid, clothing drive, political and other pertinent information for and to fellow, burned out victims and the public of Grandview Palace. The page is the only means of information and communication for the victims of Grandview Palace fire and is a vital information source, like the press, for unit owners. This is the main reason that plaintiffs are trying so hard to destroy the only means of free communication and the only lifeline left for the Grandview Palace public. Plaintiffs are attempting to destroy the free press of Grandview Palace by suing one of the leaders and scaring others from public participation and petitioning. Defendant and many others wrote letters, circulated petitions, met and called public officials, displayed signs at public meetings, spoke at public meetings, reported unlawful activities, and filed official complaints against plaintiffs reporting their misconduct. Plaintiffs publicly expressed their displeasure with defendant and others' activism. Plaintiffs publicly ridicule and slander defendant at public meetings, auctions, and vehicle sale. Publicly, degraded and defamed defendant by calling him a stupid idiot and shouting at him to get out of here. On or about August 1, 2012, Grandview Palace 2 insurance companies filed a lawsuit refusing to pay approximately $74 million in fire claims, citing misrepresentation and insurance fraud by the Condominium Homeowners Association, Board of Managers, and charging them with falsifying the insurance policy's applications, tampering with evidence, and hindering the investigation into the cause of the fire, under the advice and counsel of plaintiffs as attorneys. Upon information and belief, plaintiffs are responsible for the denial of insurance proceeds, due to their attorney negligence, misrepresentation, improper actions, bad advice, misconduct, profiteering, and greed. Plaintiffs issued the wrong decision to refuse access to the fire crime scene insurance company's investigators, and to tampering with evidence. Hindering the investigation and evidence tampering are alleged in the insurance company's denial lawsuit and is the reason why 396 unit owners were denied their $74 million claim. Upon information and belief, plaintiffs are guilty of legal malpractice, negligence, breach of fiduciary duties, and breach of contract, fraud, and perjury. Plaintiffs as attorneys did not use reasonable degree of care and by bluntly and shockingly refusing access to fire investigators and removing evidence, created an air of suspicion as to the cause of the fire and hence the denial of claim. Plaintiffs as attorneys admitted to removing evidence at a public meeting of the general membership on November 18, 2012, thereby violating attorney-client privilege and giving the insurance companies more ammunition to further deny our claim. Upon information and belief, plaintiffs breached their fiduciary duties. Attorneys owe the client a duty of utmost good faith. Plaintiffs place their own interests above the interests of the client. Grandview Palace. Plaintiffs as attorneys are taking advantage of their position to excessively gain and profit at the expense of their client. Upon information and belief, plaintiffs as attorneys may have committed fraud. An attorney commits fraud if he makes a misrepresentation that he knows is false with the intent that the client act on it and the client eventually acts on it. An attorney may also commit fraud by failing to disclose or concealing facts, if the attorney knows the client is unaware of the facts, and the attorney intends to induce the client into taking some action by concealing the facts. When an attorney breaches his fiduciary duty or violates the Deceptive Trade Practices Act, the attorney's conduct could be fraud, as the case here. Plaintiffs are controlling the octogenarian board of managers, taking advantage of their age and ill health, especially after a major life-destroying fire, misleading and misguiding them and the HOA, just to pad the billable hours. Plaintiffs have no hearts and are taking advantage of octogenarians. Plaintiffs as attorneys failed to conduct themselves in a professional manner and perform their fiduciary, contractual, and ethical duties as true attorneys. Plaintiffs are charging unit owners to find out their maintenance arrears. Plaintiffs have refused to release associations' financial, maintenance and other records. Defendant spoke up and was slapped. Plaintiffs are acting against the best interest of Grandview Palace Homeowners Association and their bad advice and decision caused the HOA $74 million. Since the fire and denial of insurance, most of the 396 unit owners became outraged and started questioning everything, publicly expressing their distrusts and lack of confidence with plaintiffs as attorneys for the HOA. After losing their homes, they now find out that they will not collect on the insurance policies due to bad advice and decision of plaintiffs as attorneys. Defendant and others further organized, petitioned, and encouraged the 396 unit owners of the HOA to continue questioning everything and to participate in the filing of complaints against plaintiffs and the Board of Managers with many governmental agencies. Defendant and many others began questioning the cause and reason of the devastating fire and the denial of insurance proceeds.